Our speaker this morning is E. Randall Schoenberg. Randy is a volunteer curator of Genie and one of Genie's most active users, managing over 120,000 profiles. He is a board member of Jewish Gen and the co-founder of Jewish Gen's Austria-Czech Special Interest Group. Randy administers the Schoenberg Family Tree DNA project, and he is also the author of The Beginner's Guide to Austrian Jewish Genealogy and the co-author of Getting Started with Czech Jewish Genealogy. Professionally, he is an attorney and serves on the board of various philanthropic, artistic, and educational organizations. Randy, I know you are a great friend of the Hebrew University of Jerusalem, which I am a teacher in the law faculty, and we thank you greatly for your friendship. Randy was the co-founding partner of Boris Schoenberg and Walden LLP, where he handled a number of complex business litigation matters, specializing in cases involving looted art and the recovery of property stolen by the Nazi authorities during the Holocaust. You all must have seen The Woman in Gold. Randy, thank you for coming.
Thank you very much. Thank you. So it's a great pleasure to be here in Jerusalem again, and certainly a good pleasure for me to finally be speaking about something other than the Klimt paintings today. So what I'm going to do today actually is more of a paper presentation. I've been working on an article on this topic, so I'm going to read, unfortunately, the article, but hopefully at the end we'll have some time for questions or comments. So anyway, I hope it's of interest to all of you. It's been very interesting for me to put it together. So it's become the time for me to start using these. So I hope everybody's fine with that. Now, so glad this is being filmed. Okay, so here we go.
Randy, excuse me, there is a translation available. If you need translation, you can take the headphones from the outside.
Okay, so let's get started. The right to privacy is a relatively recent legal construction, and one that is still evolving. As genealogists, people whose goal is to learn and write about personal details of other people, we often hear complaints about invasion of privacy. So I believe it is worth exploring the issue in some detail to understand what rights exist at present and what might evolve in the future. Since much of our work is done online, I will also address privacy issues related to online trees on various platforms. Although Judge Cooley, in his 1888 treatise on torts, had argued for a right to be let alone, prior to 1890, no English or American court had ever expressly granted relief based on any right of privacy. In 1890, Louis Brandeis, you see his tree over here on the slide, a Kentucky-born lawyer in Boston with Jewish roots in Bohemia, who later would become the United States' first Jewish Supreme Court justice, penned a Harvard Law Review article on privacy with and at the urging of his friend and colleague Samuel D. Warren. Here's Warren, if you want to see his tree. In The Right to Privacy, Brandeis and Warren argued that the legal principle of a right to privacy should be acknowledged under the law. The impetus for the article, which is considered by many to be the most influential law review article ever written, might strike us today as quaint. Warren, who in 1883 had married the daughter of U.S. Senator, Secretary of State, and one-time presidential candidate Thomas F. Bayard, oh, there he is, there's Bayard, was concerned primarily with gossip columns. The press is, here's what they wrote, and I'll let you read that as I describe it. But you can see what they were concerned with. Scholars have speculated for decades on what particular gossip might have so irked Warren. In 2007, Amy Gaida published an article analyzing press coverage of Warren and his family. Thanks to his father-in-law Bayard's political prominence, Warren and his wife had been frequently mentioned in society reports describing family weddings, funerals, and parties. Although the coverage was quite tame from today's perspective, The family was no doubt a bit sensitive when in 1889, 3 years after the death of Mrs. Warren's mother, the newspapers reported that her 60-year-old father was to remarry a woman 20 years his junior. The newspapers had earlier reported on Mrs. Warren's friendship with President Grover Cleveland's 21-year-old bride, Frances Folsom, whom the bachelor president had married not long after the press had disclosed the existence of Cleveland's illegitimate child from a prior affair with Maria Halpin. But perhaps the prurient gossip was just imagined, as nothing salacious has yet been discovered that would justify the outpouring of anti-press rhetoric contained in the Brandeis Warren article that you see here. Nonetheless, the article, The Right to Privacy, led to the development of 4 related but distinct categories of privacy rights, as delineated by University of California, Berkeley School of Law Dean William Prosser in his seminal 1960 article on privacy. Dean Prosser is also extremely famous. Here are the four categories. The first is appropriation. The first right of privacy to be adopted was the right against appropriation of name and likeness for commercial purposes. This right limits the ability of advertisers to use the names, faces, and voices of celebrities and others in films or advertisements without permission. This category could also come under the rubric of false advertising, since the purpose is to prevent misleading suggestions of celebrity endorsements, as well as protecting the right of celebrities to profit off the fame, off their own fame by endorsing products. The second category is intrusion. The right of privacy has been used to bar physical intrusion, searches, eavesdropping, wiretapping, and hidden sound and video recording. This aspect of privacy requires an affirmative act of prying or intrusion that a reasonable person would consider objectionable. And the thing intruded upon must, in fact, be private. So, for example, it is not an intrusion to watch, follow, or even photograph a person walking down the street, although it would be to use a selfie stick to film up a woman's skirt. Okay? The third category is public disclosure of private facts. A cause of action can be brought for objectionable publicity given to private information, even if true. A 1931 case involved the revelation of the present identity of a former prostitute who had been a defendant in a murder trial 7 years earlier. Other early cases involved publication of a person's debts. The facts must be private facts, not generally known to the public, that are offensive or objectionable to a reasonable person of ordinary sensibilities. The last category is false light in the public eye. In these cases, the invasion of privacy is a result of attributing to the person some generally embarrassing or objectionable attribute that he does not hold. For example, if one were to take a picture of a random person and place it in an article on syphilis sufferers, this would be considered an invasion of that person's privacy. This category is perhaps quite similar to the law of defamation, since it applies only to false and misleading attributions. There are limitations and defenses, of course, to the action for invasion of privacy, most notably the common law privilege and in the United States constitutional right to report on and discuss public figures and events of public interest in the press. For public figures such as politicians and celebrities, there is no invasion of privacy unless there is a finding of malice, which is to say, an intentionally false and misleading publication of private matter designed to harm the subject and not for the legitimate purpose of parody, opinion, or public comment. I've gone into this detail in order to demonstrate that mostly what we call the right to privacy has little or nothing to do with what we do as genealogists. Certainly, the first and last categories, appropriation and false light, have no possible connection to genealogy, since we are not in the business of using people's names for commercial advertisements or films, nor do we intentionally add false facts to our family trees in order to embarrass people. Intrusion also would not ordinarily be an issue of concern, unless perhaps you are in the habit of using unorthodox methods of obtaining genealogical data. Slow down. Okay, I will slow down a little bit. For example, I suppose hacking into private adoption files might give rise to an action, but barring something egregious like that, the only possible category that could concern what we do when we build family trees is the one pertaining to public disclosure of private facts. Before we delve further into the right against public disclosure of private facts, I want to suggest that in my personal opinion, this category is ripe for reevaluation. The old cases that first gave rise to the concept increasingly seem old-fashioned and out of date. What we often do when we limit disclosure of private facts that ordinary people deem offensive and objectionable is perpetuate stigmas. Promiscuity, homosexuality, illegitimacy, infidelity, etc., were long considered so objectionable that the mere mention of the fact, even if true, was considered offensive and affront to public morals. By limiting disclosure and discussion of these facts, the stigma was reinforced. Their absence from the public sphere made their occurrence seem more rare and unusual than they in fact were. Yet, the considerable change in public opinion on these issues has demonstrably been the result of more disclosure and discussion. For example, the controversial practice in the 1970s of publicly outing prominent homosexuals under the protection of the reporting privilege has no doubt led to the great advances for the homosexual community that we have seen in the past decade and indeed the past weeks. Disclosure can lead to the erosion of the very stigma that makes the fact objectionable by making the presumed deviant behavior more apparent, even ubiquitous, and therefore less threatening. We need to be cognizant of this when we consider the rights of individuals to prohibit public disclosure of private facts based on the current state of public mores. Protecting privacy in some cases reinforces the need for privacy by affirming the stigma attached to an otherwise unobjectionable fact. Okay. That is not to say that there is no need for privacy. The law already delineates a number of areas where privacy is protected and disclosure cannot be compelled. For example, the attorney-client privilege protects the conversation between a lawyer and her client so as to foster a more open and trusting dialogue without fear that an admission made to an attorney can later be used as the basis for a prosecution. Similarly, the law protects what you say to your doctor, and by extension, the results of medical tests. Conversations between married spouses or a priest and a penitent can also be privileged from disclosure. The same also applies to tax returns. Turning now to genealogical data, however, the existence of legal protections is less than clear. Are there, in fact, legal limits on what can and cannot be published on a family tree? That is the question. Okay. Let's move ahead. Let us first attempt to differentiate between living and deceased people. Do the deceased have privacy rights? And if so, how are they protected? Since dead people cannot assert rights for themselves, this question is related to the question whether privacy rights can be asserted by heirs on behalf of someone who is deceased. With regard to the right against misappropriation of likeness, the common law did not extend to heirs any rights to assert a claim. There's a famous case concerning Bela Lugosi and the Count Dracula character. Subsequent to that case, California passed legislation giving heirs rights against appropriation of likeness, and that has been enacted also in many other jurisdictions. However, no statute has extended such inherited rights to claims for public disclosure of private facts, which, as we demonstrated above, are the only aspect of the right of privacy that would pertain to genealogy. Therefore, absent new legislation, there is no right of privacy issue with regard to disclosing facts about deceased individuals. This means that as far as the law is concerned, genealogists should feel free to disclose genealogical data and even embarrassing facts about the deceased. No legal claim can result from such disclosure. With regard to the living, the rule against public disclosure of private facts applies. The facts privileged from disclosure must be private facts. Let's go back to the previous slide. Private facts, not generally known to the public, that are offensive or objectionable to a reasonable person of ordinary sensibilities. Regular genealogical data regarding name, date, and location of birth, marriage, and death, the names of parents, siblings, spouses, and children should almost never give rise to a claim for invasion of privacy. Since these facts are not usually private, but are known by a wide range of people, and further are not offensive or objectionable to a reasonable person. As Dean Prosser explained already in 1960, quote, "No one is entitled to complain when there is publication of his recorded date of birth or his marriage," end of quote. With regard to some embarrassing private facts, however, the genealogist is probably wise to tread with caution. If it is not generally known that the milkman was your cousin's father, it is probably not wise to publish this fact. By extension into the modern world of DNA testing, disclosing that a father does not share the Y DNA haplogroup of his putative son could also be problematic. That is not to suggest that liability will result from disclosure of any such facts. There may be defenses in any particular case, and the existence of damages from an objectionable disclosure might be uncertain and may depend on how many people will have seen the disclosure. Remember that the test is not whether the supersensitive subject objects, but whether a reasonable, ordinary person would find the disclosure objectionable. Even the milkman example might not rise to this level, especially if the publication was just for the purpose of a family tree. There are today not many genealogical facts that the ordinary person might find truly objectionable if disclosed. Adoption, homosexual relationships, out-of-wedlock births, and in the wake of Bruce Jenner, even gender transitions may now be safe to disclose as the stigma previously applied to these facts has receded. By contrast, the public disclosure that a birth was the result of rape or incest might still be thought sufficiently objectionable and may give rise to a potential for liability. A genealogist should use his or her best judgment in these cases, but there is no hard and fast rule to rely on. I want to repeat again that the objection of the individual concerned is not relevant to the legal question, so long as the fact itself is neither private nor objectionable to an ordinary, reasonable person. Genealogists commonly hear complaints from people who fear the disclosure of their birth date or mother's maiden name, often because of an irrational fear of so-called identity theft. The truth is that what is commonly called identity theft is in reality just garden variety fraud, and it is accomplished without the use of genealogical data. The most prevalent type is the result of theft of credit card data from merchants. The thief steals the credit card information, usually in bulk form from a computer file, and uses it to make a purchase. No family tree information is utilized. The other type of identity theft is when someone applies for credit in your name. This type of fraud is ordinarily perpetrated by a bank teller or someone in your home, someone who already has access to your mail, your phone, your address, your date of birth and social security number. Again, no search for genealogical data is really involved. As far as I have been able to determine, and I've been asking and looking at this for years, there has not been even one documented case of identity theft involving a family tree. Not one. So, to return to the question, an individual's irrational fear of identity theft should not give rise to any claim for violation of the right to privacy against a genealogist, because an ordinary, reasonable person would not have such fears, as the true risk of damage or embarrassment is zero. Thank you. This means that as genealogists committed to public genealogy, we should feel free to ignore the objections of those with irrational fears about the disclosure of commonplace genealogical facts. At least from a legal perspective, we have every right to disclose those facts. They are neither truly private, nor are they objectionable or damaging. Private facts do not include information that has been voluntarily disclosed to a third party or knowingly exposed to the public. Many people know your date of birth. Think of all those birth announcements and everyone who ever celebrated your birthday and came to your party. Your mother's maiden name is not private. It's known to a wide range of people, namely everyone who ever knew her, at least prior to her marriage, and who also knew her parents. These facts may be published because they are not private in any sense of the word. Compare them to the truly private conversations between an attorney and client or doctor-patient, spousal, or priest-penitent privileges. You cannot make an otherwise public fact private merely by wanting it to be private. As a result, with few exceptions, ordinary genealogical data may be published without giving rise to any potential claim for invasion of privacy. So far, I have focused on American rules. But what about the new push for a right to be forgotten or right of erasure in the European Union and elsewhere? Jan Meisels-Allen has been following the worldwide developments closely on behalf of the IAJGS Public Records Monitoring Committee. There are many facets to this development, and it would probably be better if they were being dealt with separately. Instead, Europe seems on the verge of passing sweeping legislation that could have very serious consequences for genealogists. In the United States, the line between public and private actors is more defined than in the more socialized European Union. And this has led to some of the confusion, I think. On the one hand, there is the concern for government data collection. Disclosures of mass data collection and snooping on foreign officials by the NSA have raised privacy concerns in the United States and abroad. In the United States, these concerns are focused mostly on government collection of data, restricting both the collection of data and the ability of individuals to access the data that is collected by the government. There is, however, no serious discussion in the United States of limiting the ability of private companies and individuals to collect and use data. Americans are committed to free speech and free enterprise, and they bristle at the idea that the government could hold a monopoly on big data or use it to invade privacy. We are less concerned with abuses by individuals than we are in protecting our freedom from government intrusion and restraint. As a result, our privacy laws are directed at limiting government and protecting property, as in the Fourth Amendment right against unreasonable searches. Americans to be less concerned with what private corporations and individuals do with the data that is collected, as that would infringe individual liberty and property rights. By contrast, in the European Union, where the governments generally are more involved in people's lives and often own stock, even in large corporations, the idea that governments should be restricted more than private corporate or individual actors seems almost not to have been considered. Europeans appear not at all concerned with a potential government monopoly on information, but are apparently very concerned that their neighbors and large corporations might be collecting data. For example, in Germany, the law requires every individual to register his address with the police when he moves to a new home. The ability of the police to know the whereabouts of every person in the country is simply accepted as a fact of life without any concern for privacy. No such law could ever be passed in the United States. And so it is in Europe that we see an increase in data protection laws designed to allow ubiquitous data collection by the government, but prevent private individuals from accessing even relatively ancient records for fear that someone might learn something that the government already knows. I would argue that the European focus on limiting private access to data while allowing widespread government data collection is misguided. If European history of the past 100 years teaches anything, it is that the danger lies in the abuse of government power and the failure to allow private actors to balance that power. Rules that give the government a monopoly on information and data collection should therefore be adopted very cautiously. So we watch now with some concern as the European response to Edward Snowden's revelations about mass data collection by the NSA is to insist that Google allow people the right to erase true stories from their data servers, require Facebook to enact default rules in favor of privacy, and allow municipal archives to deny individuals access even to quite ancient genealogical records. In contrast to the United States, Europe's answer to privacy concerns is to continue to allow data collection by the government, but limit individual rights to access and use not only government-collected data, but data collected by individuals and corporations. This is not to suggest that the United States does not have any restrictions on the availability of public records. Census records, for example, are sealed for 70 years, and in the United States there are various restrictions, depending on the state, on access to birth and marriage records. But these restrictions all pertain to access to public records, and not at all to online family trees or other data published by individuals or corporations. In Europe, however, the proposed Europe-wide rules with regards to the right of privacy may ultimately restrict the ability of private individuals to publish genealogical data, just as they are restricting the ability of Google to provide links to old news stories. As Jewish genealogists, these developments underscore some of the strong philosophical differences between attitudes of Europeans and Americans toward publishing genealogical data online. With the rise in anti-Semitism in Europe, we hear more Europeans expressing fears that the publication of Jewish genealogies could lead to anti-Semitic attacks. In other words, many people now wish to hide their Jewish background. Seeing no difference between government persecution under the Nazis and private anti-Semitic attacks, their answer is to claim a right to limit access to records, insist on rights of erasure, and protect their right to hide their Jewish background. The desire of some European Jews to hide fits very nicely, it seems, with the anti-Semites' desire for Jews to simply disappear. And so governments, I think, are leaping at the opportunity to restrict access to archives and enforce expanded rights of privacy and erasure. The added benefit of these data protection rules for Europeans is that they also limit the ability to discover and disclose criminal acts, especially ones committed during the Nazi era. I have a former client who called the German rule for data protection Datenschutz. He called it Verbrechenschutz, which means protection of criminal behavior. This may also explain why these sorts of laws are gaining more traction in Europe than in the United States. There's more to hide in Europe. In sum, we may be heading toward a legal regime where publication of Jewish genealogical data is permitted in the United States, but prohibited or at least potentially restricted in Europe. The right to be forgotten and right of erasure emerging in Europe extend far beyond the right against public disclosure of private facts as developed in American jurisprudence, based as they are on the subjective desires of the individual and not the reasonable objections of an ordinary person. But so far, at least, there is no restriction on the publication of genealogical data in the United States or Europe. The recent decisions are based solely on a directive concerning privacy and have not been codified. The proposed European law governing rights of erasure is not yet final and is still being negotiated. We'll have to wait and see what new privacy law comes out of the European Union and how it will affect online family trees. Okay, now to the online family trees. Multinational corporations who do business in both the United States and Europe are facing a dilemma of how to react to the increasing demands for online privacy laws. Google and Facebook are at the forefront of this battle, but they are not alone. Genealogy sites such as Ancestry and MyHeritage and Geni also have to tread very carefully through this changing legal landscape. But as we will demonstrate, the leading online genealogy providers have established rules protecting privacy that go way beyond what is required under American or European law, probably out of market considerations. On Ancestry, So let's see. There we go. Which allows users to build individual family trees. The default setting is public for deceased profiles, which means that other subscribers can view all content in the tree except information about living people and notes. There are 2 additional levels of privacy that one can select on Ancestry to make the tree more private. Trees designated private can be viewed by other subscribers, but limited information about deceased individuals in the tree, name, birth year, and birthplace, will appear in search results with Ancestry sites. For added privacy, one can prevent the tree from being indexed and found in searches. The tree owner can invite others to share the tree and also decide whether to allow invited members to see living people. Public trees on Ancestry may be searchable via Google and viewed by non-subscribers on what they call the historical person search pages that Ancestry allows Google to index as part of its marketing and promotion activities. However, as far as I can tell, there is no way to guarantee that your Ancestry tree will be discoverable in a Google search. They select it according to their whim. MyHeritage protects privacy in much the same way as Ancestry. I think I have a slide there. Okay. Its privacy policy states, we recognize the sensitivity and confidentiality of information that may be disclosed by users in registering, making purchases from our website, or performing their family history research, and we are firmly committed to protecting your privacy. That's their policy. Each tree has a webmaster and site manager who can invite others to join the tree as members or guests. Living profiles have their first names, dates of birth, gender, and photos hidden unless the user has been given access to the tree as a member. However, this is an important distinction, unlike Ancestry, on MyHeritage, users without access rights can still see the last name of a living person on the tree. So it means you can find the maiden name sometimes that way. Users have a host of privacy options regarding access and content, including whether to allow people to find the tree or request membership, include the tree in MyHeritage search engine, or enable smart matching with other trees on MyHeritage or its partners like Genie. Also, whether guests can view the tree on search, view or copy photos, all of these you can toggle and change on MyHeritage. Like Ancestry, information from public profiles on MyHeritage may or may not appear on Google searches as a result of the company's marketing efforts. Okay, Genie. Genie, which was acquired by MyHeritage in 2012, operates an online collaborative tree that requires somewhat different rules. Genie's World Family Tree presently has over 93 million connected profiles with well over 3 million users all working together on the same tree. On Genie, profiles are divided into 2 groups, public and private. In general, living people are private and deceased are public. Genie will permit users to make deceased profiles private, but they may be made public again by other users or curators, especially if the person in question was born more than 150 years ago. Celebrities and other public figures who have been designated as master profiles by one of the Genie volunteer curators are also public, even if they are living. A user can make his or her own profile public as well. Profiles that are marked living, but which are presumed deceased because the birth date is several hundred years ago, are also made public. Private profiles can be viewed by people inside the family group of the profile, which is defined as fourth cousin or less. Additionally, curators and anyone who has been added into the family group of a manager of the profile can view and edit the manager's private profiles. It's a little complicated, but that's the rule. Genie's volunteer curators sign non-disclosure agreements and agree to keep private information confidential, but they are given access so that they can assist other users and help resolve issues in the tree. In contrast with Ancestry and MyHeritage, public profiles on Genie are fully indexed and searchable on Google. And Genie's search engine optimization is very good, so the profiles often appear very high on Google search results. Genie allows a limited right of erasure such that individuals may request deletion of their own profiles and those of their surrounding immediate relatives, subject, of course, to the possibility that someone else will add them back into the tree. I think I have another example. 10 minutes, okay. I have another example of a tree here. Bibi Netanyahu, right? Okay, so you can see what it looks like. Right, he's living, but he's public because he's a master profile. But his family, you can only see the last names. Okay. I've described the policies of Ancestry, MyHeritage, and Gini from the perspective of those who want privacy. But what about those who want to publish their trees and are not concerned with privacy? Because of the privacy restrictions imposed by the various companies, there is no collaborative online platform where you can publish your tree openly without restrictions. The only option for a public family tree is to have your own website. Programs such as Reunion or Family Tree Maker will build web-based trees that you can upload to your own website. People who want a fully public tree frequently use this option. As we have demonstrated, companies such as Ancestry, MyHeritage, and Gini have developed privacy standards not as a result of legal requirements, but as a marketing strategy. Again, there is no law in the United States or Europe that requires any portion of a family tree to be private, or that prohibits anyone from placing a fully public family tree, including living people and minors, on the internet. Not only are there no laws restricting online family trees, but the online companies are protected from any possible liability as a result of internet safe harbor rules, which prohibit lawsuits against providers of online forums for users who post their own data. The limited number of European cases on the right of erasure so far concern deletion of links to embarrassing criminal or debt-related items from search engines, somewhat in line with early common law cases that I discussed above concerning public disclosure of private facts. To my knowledge, there has not been any case brought in the United States or Europe concerning an online family tree, nor could there be under the existing legal regime. The internet has greatly changed our notions of what is private and what is public, and has changed our notion of what it means to publish. Access to information has exploded. What formerly was known and available to a small circle of local friends and neighbors is now accessible to billions of people across the globe simply by putting it on a website. Many people are still adjusting to this new reality. The more paranoid and narcissistic among us have become even more so. There is a tendency for us to want to believe that everyone else in the world thinks that we are as interesting and important as we think we are to ourselves. But that is obviously not true, and there is good reason not to be carried away. It used to be that when the government collected information about a person, it meant that someone somewhere had identified and targeted him or her for surveillance. We established safeguards against unreasonable, unwarranted searches to prevent abuse of that power. But we should not pretend that our concerns should be the same when the government engages in mass, untargeted data collection. Alarmists like Edward Snowden and Glenn Greenwald, his publicist, and companies selling security products have preyed on our natural narcissistic paranoia and our inability to comprehend large numbers to stir up demand for greater privacy protections and products. The truth is that no one cares about any of these things that we are trying to hide when we try to erase things. 7 billion people may have access to your date of birth or mother's maiden name, but it is still just your neighbors, friends, and relatives, the people who already know you and are connected to you, who will ever look for you and find you on the internet. It is time to start thinking about what it is we are doing when we give people the right to erase and hide facts about their lives and prevent other people from finding them. Scientific inquiry, freedom of thought and expression, artistic freedom, the ability to analyze history and discuss issues of public concern, all of these are human rights as well. For genealogists, especially those of us committed to the idea of building a world family tree, it is time that we spoke up and defended our own rights and interests. Outside of the publication of truly objectionable private facts, there really is no such thing as privacy in the context of a family tree, nor should there be. Thank you very much.
Thank you very much. Our speaker will take some short questions. We have 5 minutes. If you have any questions, please approach the microphone, and please keep your questions short in order to allow others to have the ability to ask again.
Could you comment on the Social Security Death Index and all the privacy issues going on with that? They shut it down one day, and I don't understand why.
Yeah, so the Social Security Death Index was published in full in order to prevent fraud, really. It allowed people to check to see if the Social Security number being used was from someone who had died. Then recently there was some effort to take it down because of privacy concerns. And I'm not fully aware of the current status of that. I know that you can still find some of that information online.
Most of it's blocked everywhere, as far as I can tell.
Some of it is blocked. Some behind the paywalls, you can still find it. That's I think.
Thank you.
But like, for example, I know on MyHeritage, I see Social Security Death Index information.
Next question, please. Please line up behind the microphone.
In 2007, when Jenny was relatively new and I didn't know anything about it, a distant relative in America sent me an email and said, I am putting family information into Jenny in your name. And I was about to leave Israel for the United States for a few weeks, so I answered him, I'm going away, I'll look into this when I come back. By the time I came back, I discovered that he had put material full of mistakes in my name onto Jenny. And I didn't have anything to do with it, and I haven't had anything to do with it. Years later, and it has grown. Many people have attached to this, and there's a lot of misinformation there. Can this be taken? Can the name be changed? Can I take it out of my? It's my wrong name, by the way. It's not my correct
So
name.
impersonation is not allowed, and you should talk to one of the curators, and they'll help deal with that. So someone can't impersonate another person on Genie, and the curators and Genie staff can take care of that.
Thank you.
You touched on the European situation and on their special drive for data protection. We have the case that in the North Rhine-Westphalian city of Minden, they put a memorial book of the former Jewish citizens of Minden on the internet. A few relatives turned to the North Rhine-Westphalian data protection man, claiming that they felt exposed like in previous times, only now with very modern means. So he advised the Northern Minden community to take it off. They complied, but they asked for various legal briefs, and they are now prepared to put it back on after August 1st. But in principle, this is what you mentioned before, that this is getting to memorial books and trees of victims of the Holocaust.
Right, and there are descendants, there are non-Jewish descendants who don't want to know that don't want anyone still to know that they have a Jewish grandmother and things like that.
Right, they explicitly said they felt exposed, an den Pranger gestellt.
Right.
As if this was a crime.
Yeah, it's still a conflict. Thank you.
Thank you.
I will forward the whole thing to you.
Thank you. It's
We'll
very
take
relevant.
3 more short questions, please.
Very, very short question. You brought out very well the legal aspects, but there are privacy issues that are ethical or a kind of thing that you can alienate relatives and friends if you publish information that they don't specifically want to be published.
So I only dealt with the legal issues. I think people don't, when they talk about being offended, they don't consider how offensive it is to a genealogist to change a family tree, to delete information, to have it not be complete. There are 2 sides of this, and I think those of us who are genealogists and have that obsessive compulsive disorder that we need to have a complete tree, need to sort of stand up and say, listen, we have our craziness too, right? You may be paranoid and think that no one can talk about you without your permission. I have this issue where I have to put everything on my family tree. Sorry, we both have these psychological problems. Can we still get along together? I think that's the way the discussion has to go, instead of what I frequently get is, how dare you put my name on this family tree? And I said, I'm sorry, you're my sixth cousin, right? It's, how dare you tell me not to talk about you, right? Is my response sometimes. So anyway, there is always peace in the family, right? Shalom Beit, right? You have to keep peace in the family, and every one of us has to deal with that, and there are circumstances when I've had to deal with that genealogically also.
Thank
But
you.
why would you delete
Sir.
photographs? That's a question.
I need everything on my family tree. I'm as crazy as the person who doesn't want to have it on. So what do we do about it?
Thank you very much.
Yeah.
This is an extension to what the previous person asked. For instance, I had one case of a woman who we had a very positive relationship, and I came out with the information that she was born out of wedlock, and she was very embarrassed by that. She knew it was true, but she didn't know that anyone else knew about it or could find out about it. She specifically asked me not to publicize it for obvious reasons. What you're saying is that if I want to publish it, I can publish it, and as a genealogist, I think that's very counterproductive.
Well,
because what you're going to do is alienate the people who you need the information from.
Okay, so there are two issues there. The legal issue, remember, is this
No,
was
I
the
understand. Legally, I can
legal
do
issue
it.
is the one. That's the one area.
No, I could do that. She was born 2 years before her parents were married.
That's the one area where you do need to be careful. Okay, as I mentioned, that disclosing that the parent is not the parent, right, could still be on this line of disclosing a private fact that is objectionable to an average person. Could be. I'm not saying it necessarily is.
Is
So
that a private fact?
Sorry?
It's publicly available, the marriage date and the date of birth. And the,
You're
marriage,
sa-
and the marriage date was after the date of birth. 2 years. So that is publicly available.
Okay, but those two facts might not be, but the fact that the father isn't the same, right? People get married after the kids are born all the time. So that's a
Not
different
50
issue.
years ago or 70 years ago.
That happens all the time. Matter of fact, it happens all the time in Bohemia, where no one was allowed to have official marriages, and so they get married at age 70. Okay, so it happens all the time, but that's an area where you need to be a little bit careful. You probably are okay publishing it, but you're right. There are considerations of, in the family, do I want to be a pariah? Will I ever get any other information? And you have to decide that on a case-by-case basis.
Randy, can we please take one more question
Yes.
from Jordan Auslander? We are running out of time, so
Just the issue is to be sensitive.
Thank
we have
you.
to be sensitive.
thank you.
Each of us have our own sensitivity.
Jordan,
yes.
a short question.
Yes. It's my understanding that a death certificate under the law is only proof of death, and the other information on that certificate is hearsay. My question is the excuse of keeping the names of informants, parents, or even cause of death grounds to keep public documents, say like a death certificate, from the public?
Okay, so two questions. The question of whether something's legally admissible or not as hearsay is much different than whether we should use it as a genealogical fact in a family tree. I mean, it may affect a professional genealogist who's presenting something that has to be filed in court, but we have separate legal protections that sometimes we exclude true facts from legal proceedings. So I understand that. So the question I didn't completely understand. The second question: should that information not be made public? Are you
Right. Is the fear of disclosing a cause of death, which many jurisdictions use as redacting that from a death certificate, or even the names of informants or the parents of the deceased, is that reasonable grounds for keeping a document such as a death certificate from public view?
So I think no, because as I said, dead people don't have privacy rights. So there shouldn't be any problem in disclosing everything on a death certificate, in my view. But I haven't looked at it specifically from that angle.
All right, thank you.
Randy, thank you very much for a fascinating talk.
Thank you. Thank you, everyone.